Hello, everyone. Today we shall discuss a few myths about the EU Act. My name is Alexander Tulkanov. I'm an AI governance advisor, and you can, if you like this webinar, you can follow me on LinkedIn here or on X, formerly Twitter, or wherever you are watching me. And we'll pass directly to the issue of the day. So we'll talk about a few myths. There are many of them, and we will not necessarily cover everything today, of course, but at least we shall try to focus on a few of them, and as they relate specifically to the classification of AI systems as they appear in the Act. In fact, and so far you may have seen, you may have heard numerous presentations and numerous thought leadership pieces are reproducing information about the so-called pyramid of AI systems, which is allegedly provided by the EU Act, and the so-called category of limited risk AI systems. And there, in this, representation, this kind of representations usually considered that there is such a category of AI systems as limited risk AI systems. And the source of this confusion actually is this chart, which originally has been quite popular because it originated from actually the European Commission. Not exactly in this form, but the idea is represented here. And the idea was to try and show that actually there are certain categories of AI systems which are either covered by the Act or slightly covered in the sense that certain AI systems will be completely prohibited as soon as the EU Act starts to apply. Certain AI systems will be subject to very stringent obligations, and there will be some further types of systems. And the argument of the European Commission was that there will be a predominance of those systems, which will be subject to a very limited number of obligations. And it will not significantly, therefore, this new upcoming regulation will not, therefore, significantly affect the market, right? So, and this pyramid was conceived in order to, exactly show and give the understanding of this idea that, a larger portion of the ASM systems will not be strictly, so to say, regulated. And there were some examples given, and these examples have been reproduced multiple times since then. And you can see here basically, and what was the understanding of most people who got acquainted initially with this diagram was that either your AI system is high risk, right, or it's prohibited, or it has only limited risk, right, and it's subject to transparency obligations, or just subject. It falls under the minimal risk category, and then basically the compliance becomes voluntary. Yeah, in this case. But the fact is, this edit, this attempt to demonstrate the like the predominance, the number of systems which are going to be affected, the proportion of different types of ASIPs which are going to be affected differently because of the act. This caused confusion among many people, and those confusions have led to the fact that this sort of category of limited systems, limited risk systems, is considered as a separate category from high risk AI systems, where in fact, if you read the act, it's not the case. So if you read carefully what is exactly written in the act, in fact, it's there are categories which overlap in this sense. So, chapter 3 of the EU Act provides requirements for the high risk AI systems, while the chapter 4 provides certain requirements for transparency requiring uses of AI systems. And in fact, even if you take a look at the examples which are given in appropriate annexes, notably in Annex 3 of the EU Act, which deals usually with high-risk use cases. And at the same time, if you take a look very carefully at the contents of the Chapter 4 of the regulation, you will see very particular examples, but these are just examples, where in fact it will be that both legal regimes will apply to a certain subset of AI systems. For example, if you are deploying an AI system which is considered a high risk one under the Chapter 3 and Annex 3, which is used for emotion recognition or for biometric categorization, this will be the two very good examples where such use also triggers the provisions under the Chapter 4 transparency. So you will immediately see that in such case, there will be an overlap, and there will be further other AI systems which will qualify at the same time as Chapter 3 and Chapter 4 AI systems. So if we go back to the previous slide to the infamous pyramid, it is absolutely not clear from this visualization that this is the case, that there may be an overlap. You will clearly see that this chart is unfortunately confusing everyone in this regard, because it shows no overlap. It shows just two distinct categories, which is not the case, which is not true, which is not correct. So if you want to really understand how the categories overlap, there is no other way other than to read the regulation yourself, or some course material which you may be following. And I cover this topic extensively in my webinars and in my EU Act course, that certain systems will fall under these two different categories at the same time. And this is just to explain things extremely simply. If we are going to, apply the rules of the Act in practice, we will actually have to consider a much more complex picture, which is provided in the Act, right? And this more complex picture is actually visualized here. The example which is given here is based on the previous version on the previous version of the EU Act, which has been made public in January this year. But in terms of classification, nothing has changed really. There has been changes in terms of, for example, titles being renamed to chapters, right? But this is the chart which I have popularized in January this year. I've published it on my LinkedIn and elsewhere. And since then, nothing has changed really in terms of classification. There are two main categories which are subject to the regulation under the EU Act: AI systems and AI models. And you will see that in the AI models, in the AI systems box, there are AI systems subject to high risk requirements, and AI systems subject to transparency obligations, and there is an overlap, right? And there are some further figures you will see. I will not be discussing them in detail during this webinar, because it takes too much time to explain all of this. And if you are interested in understanding better what in fact all the categories which are depicted here and how do we need to understand them and apply them in practice, I suggest you subscribe to one of my offers, which I will suggest to you later at the end. But for the moment, for the time being, it's just sufficient to say that the picture is much more complicated than you may have thought based on popular visualizations you have seen elsewhere, like in the infamous pyramid example. And then let's talk about, again, this notion of limited risk, really, and which has been provided as a separate category under this kinds of pyramids and visualizations which are everywhere. So usually what people explain there, that the limited risk AI systems are those that are falling under the Chapter 4 EU Act transparency requirements, or use cases which require transparency. And this is simply not true. According to the EU Act, the only situation where the phrase limited risk is used in the Act, it does not concern at all this situation with Chapter 4 transparency obligations. It is not about any kind of chatbots, deepfakes, or whatever you are told. These are limited risk AI systems. This is simply not true under the Act. So what is actually the case under the Act is the meaning of limited risk as it stands currently is only explained in recital 53 of the Act. And as I will tell you again, it's not about those use cases which require transparency during development or deployment. Not at all. Limited risk use cases are those which are potentially high risk, but that are exempt. So this would be high risk AI use cases, but they are considered limited risk under some specific circumstances, in which case the high risk requirements do not apply. So this is what in fact is a limited risk AI use case. And what we're talking about here, we need to consider actually that how the high risk requirements apply, because a notion which is connected to the previous myth that the limited risk is about transparency, it's not. It's about some exemptions, and this is connected to another myth, which is obviously um, uh, perhaps evoked by other people that know about the existence of this high risk category and how it normally should apply, but then they forget about certain, additional provisions of the act, and they just say that the high risk requirements under the EU Act apply to all AI use cases which are listed in Annex 3. This is no longer the case under the current and the final and officially published version of the EU Act. So wherever you hear this, that you look at Annex 3 and that's it. Everything which is listed here is automatically considered high risk. It's not true. What is true, Annex 3 lists some potential high risk AI use cases in addition to what is specifically provided in Annex 1. So in Annex 1, there are some specific products which are subject to third-party conformity assessment under the union harmonization legislation in Europe, and safety components of such products, and there is a list which includes medical devices and other things. So Annex 3, on the other hand, lists potential high-risk AI use cases, which preliminarily you can consider them that these are likely to be the situations where you are using an AI system and it's likely to fall under the high risk category under the Act, but it may not necessarily be the case because of the exemption which I will be talking about. So what are we talking about in terms of the exemption? So the exemption which is provided right where there is a reference to all those categories and annexes. So in terms of the systems which are listed in Annex 3, right? Systems which are listed there, they may be exempted from high risk rule if they are limited in terms of their purpose, how they are intended to be used, to at least one of these four purposes. It may be a combination of those four purposes or just one of them. The main thing is here that the intended purpose is limited to this list, right? So although, and I will go back to the previous slide, although you will see here in Annex 3, certain categories which are potentially high risk, and you will see, a certain AI application, AI system, which may be used, for example, in border control management, right? And it should fall under the high risk category. But as long as the purpose of this particular system is limited to one of those 4 points, it may be exempted from the high risk rule. It's not automatically exempted, mind you, but it may be exempted from the high risk rule. And in which case this exemption takes place is important to know. So there are some examples which are listed actually in the recitals, and some further examples may be provided by the authorities later, when the Commission starts to provide us with guidance on the application of this provision in particular. But so far, what we see in the recitals are these examples. So, what is a narrow procedural task? The system is considered to perform a narrow procedural task in the examples such as those listed here, like transforming unstructured data into structured data, or detecting duplicate records. And another example is given here with regard to another purpose. The second one is improving the result of a previous human activity, in which case we are talking about such examples as improving communication tone and style. So we'll all know those kinds of applications which are on the market to really help us with such tasks, which would help us improve language or maintain a particular corporate style or another style guide which is appropriate for your university or institution and so forth. Right. The third purpose, which will be exempt, is detection of decision-making patterns or deviations without automatically acting on them. So, and the examples which are given in the recitals refer to, for example, a teacher deviating from a grading pattern, and this is detected after the fact. So it does not affect the grading process, but then after the fact, the assessment is, the grading is assessed, and the system perhaps marks a certain assessment as deviating from a previously observed grading pattern. So you will see that this would correlate with the example with example is which is provided here. For example, in Annex 3, systems used to evaluate and monitor students, for example, right? This will be normally subject to the high risk requirements, but if we take this exemption and follow the guidance which is provided in the recital, we will see that in certain cases this will not be the case as long as the intended purpose of the system is limited to this. So if it's not limited to this is another question. But if intended purpose of the system is limited, for example, to checking after the fact the grading pattern, then this will mean that this specific system is not supposed to fall under the Annex 3 and not supposed to fall under the requirements of the high risk AI systems provided in chapter 3. So, and there are further examples for point 4, which is executing preparatory task for Annex 3 relevant assessment, not considering the situation of profiling, as I've mentioned on the previous slide. So if as soon as profiling is concerned, this automatically excludes the possibility to exempt the system from a high risk category. But as long as profiling is not used, but only there is some kind of a preparation, like handling files, indexing, searching, linking data, this is supposed to be an example in the recital, which is supposed not to be classified, or supposed to be. It is supposed that it's possible to exempt the system. This is perhaps questionable in terms of how much it potentially can affect fundamental rights. Because, if we are talking text and speech processing and translation of the legally relevant information, it may in fact be the case that it will have a high impact on fundamental rights. So, including this example in the recital, serves a certain informative purpose, but may in fact actually complicate things a little bit. So we will need really to see how this plays out in further guidance from the European Commission. But so far, just bear in mind that this example is provided. But again, in the recital, not in the main body of the EU Act. And this is important because another misconception, which is I want to address here, is by looking at the previous list, you may say that actually providers may easily perhaps abuse the exemptions from the high risk requirements, right? Speaking of this example with the translation of legally relevant information of some kind that which may affect people. So if the translation is incorrect, so the quality of the AI system, perhaps the accuracy of the AI system is not up to the point where it should really be used for certain high stakes translations, maybe, right? So this may be the case that providers will try and abuse those exemptions by exempting certain, parts or of the AI systems from arguably not from the requirements which would otherwise relate to high risk AI systems. But in fact, there is a mechanism here which is provided on what basis the exemption will be applied in practice, in reality. So it's not automatic that the conditions for exemptions, the exemption will apply. The conditions are as follows, as you see, and it just clearly stated, not in the recitals, but in the main body of the Act, that actually the provider has to assess the level of risk to health, safety, or fundamental rights, which is posed by the conceived AI system. So, taking again this example with the system used for translating, for example, some document for border control purposes, right? So the system is normally supposed to be based on the scope, sector of application subject to high risk requirements, but then the provider may want to argue that actually the system is exempt because it exactly serves the purpose which is provided in the recital, which is just mere translation of the original document, right? But it will not be enough for the provider just to say so. There needs to be a risk assessment performed, and the provider has to demonstrate that it has done such a risk assessment, in particular to fundamental rights, level of risk to fundamental rights in this case. And this risk assessment should show that there is no significant risk of harm to health, safety, or fundamental rights. So you can imagine, based on this example again, how actually the provider can support his position, or how he will be having trouble supporting his position, because actually it may be the case that the translation in this case, although it's provided in the recital as a relevant example, but when applying the actual norm, which is in the law itself, in the main body of the text, the provider has to assess the level of risk, and it will have to demonstrate and document that no significant risk of harm may come about because of the operation of this system. So And this has to be done before the system is placed on the market or put into service. So you can easily imagine that this will cause a lot of trouble in terms of any provider who is attempting to abuse those examples which are given in the recitals and this rule of the act which provides them with a possibility of trying and try to exempt the AI systems which normally are listed under the Annex 3. So they wanted to exempt them perhaps, but it may be a problem to document and provide evidence that according to the risk assessment, there is no significant risk of harm. But even supposing this assessment takes place and the provider is satisfied, because it's a self-assessment, it's not a third-party assessment, that the system should be exempt. There is important provision also in the act that the provider must register itself and their exempted system, the system which he considers to be exempt, in the EU database. This is done for transparency purposes, obviously, because otherwise, everyone would really be able easily to say that, yeah, we've considered internally this is the case, the system is not high risk, should be exempt based on this consideration which we had. In fact, then this provision gives them transparency, or rather gives the public and the authorities transparency, so that they will be able to, first of all, research what the authorities will be able to research what which providers have applied for this exemption, which systems they consider exempt, and if necessary, they can verify that the exemptions should really apply, or maybe they should not apply. So this gives us a certain safeguard for using those exemptions which are there. So this ends the current fragment for today about the myths which are constantly propagated about the Act. And if you want to know more about this in a practical way, I suggest you take a look at my responsible AI webinars, which I'm offering. And if you want to go even deeper, there is a whole course which I've developed about the EU Act and preparing for the Act, which will run in October this year. So if you are interested, I would suggest that you could sign up. And thanks for being with me today. And I hope to provide you with further information on these and other topics related to the Act and AI governance later. So keep in touch. Follow me if you have not yet on LinkedIn, on X, whatever social media you are watching the stream on. And thank you. That would be all for today. Goodbye.